Okay, we are on the record in the Lovelady matter, case D19-593-140D. Starting with the plaintiff side, please confirm your appearances.
Oh, probably she left the call. What's going on?
I think we lost Ms. Beeson again. I thought I saw her.
She was up there. We're on AB Bridge.
Yeah, can everyone hear me? Okay.
Yes, sir.
You sound great, Judge.
All right, I appreciate that. I saw Ms. Beeson's name pop in. Didn't see her.
She did pop in, Judge, and she dropped back out. She's actually texting me right now. Is she saying she got kicked out?
Well, we wouldn't kick anyone out here.
I just texted her that don't worry about it. We're waiting for her.
We're waiting. So let's see if she pops back in. Let me go ahead and confirm other appearances, Mr. Schneider. If you'll confirm your appearance.
Yes, Your Honor. Good morning, Louis Schneider, bar number 9683. On behalf of Mike Lovelady, he's the father. He's present here in my office, and we're appearing by blue jeans today, Judge.
And I do see the defendant present. I also see the plaintiff present by blue jeans, and we have our guardian ad litem. Ms. Hauser, go ahead and confirm your appearance.
Good morning, Your Honor. Michelle Hauser, bar number 7738, guardian ad litem for the minor child. And just to note for the record, I've changed law firms, so I'm now with Fine Carmen Price. I'll work with Mike and Corinne because there's been some confusion.
Okay, I appreciate that. I actually looking at, I did receive the guardian ad litem report, and I see that is I didn't notice that before, but that's on the title of the document. I'm also seeing someone, the screen name is Alice Stubler or Stubler.
Yes, Your Honor. Those are the parents of the mother, and they probably need to be separated with the exclusionary rule.
Okay, they may be witnesses.
Yeah, they are witnesses.
Okay, okay, we'll go ahead and invoke that. Let's just wait momentarily. Hopefully we can get Ms. Beeson to join us.
She just sent me a text that said technology holding her head.
This technology is great until it stops working.
You know, it's been good for my dry cleaning bill, Judge. I hope we keep it for ordinary hearings and not, if in the future. And I know that's what the government wants to do, I believe, this legislature. There we
go. All right. Good morning, Ms. Beeson. Hopefully
sorry.
That's okay. Not a problem. We've had everyone confirm their appearances. If you'll go ahead and confirm your appearance.
Yes, Judge. Audrey Beeson, bar number 10511, on behalf of the plaintiff, Jessica Lovelady, who is appearing by blue jeans.
Good morning. And I do see, I mentioned before, I see both parties present. Ms. Hauser, the guardian ad litem. It's my understanding, and there is someone by the name of Alice Stubler or Stubler. It's my understanding they may be witnesses in this matter. So Mr. Schneider mentioned earlier invoking the exclusionary rule. So we can do this one of two ways. Have that witness leave the call, and then obviously they can be recalled once their testimony is going to be offered. Or we can move everyone else into a breakout session so that no one else is part of that. Is there any preference either way?
Jessica, what's your preference? Because you will have to text her.
I can just have them log off. It's my mom, not my dad. My dad is the witness.
Okay, so she's not testifying?
She's not testifying.
Okay.
Okay. Then there's no need to exclude her, Judge.
And Your Honor, just by way of explanation, I've got my law clerk, Joe Bunin, and he's at home. He's very anti-COVID, and so he's logged on. He's not going to participate, but he's going to listen and help me, Your Honor.
And I did see I saw a law clerk for you present, which is fine. So the individual designated as Alice Stubler is not going to testify?
No, sir.
Correct.
Okay. All right, so I'm fine. Again, this is a public hearing, so let me start by asking, the last time we were here was December 2nd. It's now April 22nd. In the meantime, I did sign off on a bifurcated decree of divorce, so at least in part, some issues have been resolved. Let me ask, as a follow-up to that, any other stipulations that we can place on the record?
Your Honor, Ms. Beeson asked me if I would blanket stipulate to her exhibits, and I'm normally happy to do so, but unfortunately, a lot of what's in those exhibits is stuff that was obtained, interrogatories, admissions, and things that were done during discovery, and that's a fishing expedition, and I don't want that automatically admitted. So I'm going to have to ask that we do this one at a time. But so no, I guess we don't have a stipulation, Judge, except the only thing that we agree to are things like the value of the house. We both agree to that. We can stipulate to that, Audrey. We did a second appraisal. It was at $350. We both put that on our financial disclosure forms and our pretrial memorandums. So those things are fine, Judge, but just each and every, I can't just blanket agree to all of the exhibits.
Okay.
And Judge, what I had asked Mr. Schneider is just to go through and let me know if there were any exhibits that he would be willing to stipulate to in order to expedite the matter, not that he would agree to all of them. And again, I'm just trying today. A lot of those exhibits were produced by his own client. I don't know why they would have an issue with those. And as far as the value of the house, the appraisal is stale, so we are still going to have to address that today.
Your Honor, we have a certified appraisal that I didn't even bother to list as an exhibit. I didn't even have, because honestly, Judge, and I don't want to get into an opening statement here, but we both put it on a marital balance sheet. We both based it on the latest exhibit, the latest appraisal, which is only 6 months old. So I don't know why we wouldn't agree that that's the value of the house.
What is the date of the appraisal?
It's July of 2020.
Yeah, in this market, the
That's
market
stale.
has changed quite a bit. So, well, listen, where we were, let's pick up, and as much as we've got time set aside today, time will rapidly evaporate, and we have Ms. Hauser present, who's the guardian ad litem. When we left off in December, the plaintiff, Ms. Lovelady, was there. It was the direct examination, marshaling through the specific dates of missed visits, and I don't know that I need, it's not necessarily, at this point, I recognize and I have those dates circled as the dates that were missed. Obviously the report, I've had a chance to review the report from the guardian ad litem that shed some light on exactly where Abby's at, and is helpful, and it's my understanding there's even a counseling session that's set up for this Saturday, which is good news and needs to take place. There's work to be done. This is not going to be solved in these proceedings today. I want to be very clear about this. There's some important work that needs to happen and take place, and so that being said, we can pick up at that point. I don't. To me, the issues relating to the division of assets and debts should really not be that complicated.
And I agree, Your Honor. And I believe that the court ordered that the community ended in December. So that appraisal, as of December, was only 6 months old. That was my point.
Okay, and that's a fair point. I think that decree does provide as much, and that would pursuant to Trophy Kogod, that would be the determining date for purposes of valuing the property. But that being said, I mean, ultimately, it's a matter of what do we do with property? Do we list it for sale? It's a seller's
My
market
client's
right now.
intention, Your Honor, frankly, is to pay Mom off, and she gets an advantage there because she doesn't have to pay the real estate commissions and so forth. But my client intends to keep the property, and based on that appraisal, was going to refinance it and write her, and she would get a check.
All right.
And to answer Ms. Beeson's response, Ms. Beeson's correct. She did ask if there were any I could stipulate to, and absolutely, there are many exhibits I could stipulate to and intend to. I just didn't want to do a blanket, so I think we have to do it one by one, Your Honor.
All right. Well, I think it might be helpful if there's an exhibit that's being used for purposes of examination, if you have no objection, just to let the court know at that point in time.
Thank you, Your Honor.
Okay, and Mr. Schneider, do we have exhibits from you? We're searching for exhibits.
No, Your Honor. The only focus on this matter was the court said it yourself, Judge. The number, the assets and debts is numerical. It's a formula. That we don't care about that. That is what it is. There's going to be quadros. There's pensions. There's deferred comp. Those will all be done by quadro. So that is what it is. The only thing that mattered to us was the custody portion of this. And Your Honor, I think that since the court ordered the GAL report, that's already admitted. So no, there are no exhibits other than what I'll refer to that's already in the court or Ms. Beeson's exhibits as well.
Okay. All right, I appreciate that. And touching on that, and there, Mr. Schneider referenced the issue of pensions. That is fairly straightforward. Any retirement plan should be divided by way of a qualified order, and so I would retain jurisdiction to enter any such orders regarding the division of those assets using the time rule for purposes of that division. All right, so Ms. Beeson, and what I'd like to do is, because we have Ms. Hauser present, that should really, the issues relating to Abby should be first and foremost, so that we don't waste her time when we start getting into the details of property. So, Ms. Beeson, you may proceed.
So, Judge, again, just to make it as easy as possible and for the court to see the prior fact, we had left off with the incident on October 23rd. Now, obviously, 5 additional months have passed. Does Your Honor want to know missed visitation since that time, or do you want me to wrap up with that specific weekend?
At this point, let's wrap up with that specific weekend. Again, it was a very detailed analysis, which is fine, but I get the point of the time that was missed, and I've circled those dates on a calendar, so I don't necessarily need any additional detail. We can wrap it up with that point.
Okay. So where we had left off, according to my notes, was that we had admitted my client's affidavit regarding the conversation and the recording that had happened that particular day, and I had started to ask her if she recorded the interaction. She had stated that she had, and at that point I was about to lay foundation to have recording admitted into evidence. So, Mr. Schneider, would you be objecting to admitting the recording into evidence?
No, I don't object to the recording.
And that's,
and again,
which exhibit is that?
My apologies, Judge. Let me look.
I just looked
Your
at
Honor,
it.
I just would, if I have a second, I have a clarifying question.
Yes.
Your Honor, pursuant to the order, I was supposed to participate as an attorney, and that meant I could cross-examine direct the witnesses. When I looked at this, my understanding was they bifurcated and that there wasn't a lot of testimony, and that there would be a restart. So I'm kind of like at an interesting crossroad if there's been a lot of testimony, because counsel did not make that clear when they reached out to me after I left the last hearing. Though the next thing I knew, I had a stipulation in order to select a family therapist, which nobody talked to me about before that agreement was reached. So I'm not sure how you want me to proceed if there's been prior testimony, or if you want me to do an opening argument or anything like that.
Well, the focus of the examination, the primary focus, as I recall in reviewing my outline of where we left off, was detailing the specific custodial time that the plaintiff had missed. So it was really more or less a focus on the contempt aspect.
Okay.
Not necessarily tied into the work you performed in getting to know Abby and generating your report. It was more focused on contempt. So again, I don't know that, and ultimately there's been a sufficient basis provided to establish the violation of the court's orders. So I don't know that I need much more in that regard. It's ultimately the defendant's burden at that point to show cause why he should not be held in contempt of court. And that may be part and parcel of any examination conducted by either Mr. Schneider or yourself as it relates to the missed custodial time that's been discussed up to this point. So I'm not sure that there's necessarily a lot of catching up that you need.
Okay.
And keep in mind as well, I think something that's very important, and I don't know if there have been discussions with all attorneys involved, and not to minimize what's happened in the past, but I want to be more focused on what happens in the future for this young lady. And I think that should be a priority as we map out and make efforts to grow and foster the relationship between Abby and her mother. And so that really, for her best interest, should be our focus, and even to the extent there's some level of collaboration and discussion, talking about how we make things better for Abby, how we make things better for her relationship with everyone, with the spotlight being on Mom, based on everything that's happened, and strengthen that relationship. I'd like to see that happen. I'd like to see, if things need to be rebuilt, then let's rebuild them. Let's make the effort. Something that was touched on in the report from Ms. Hauser, and this is where it's a challenge for me, and I tell parents all the time, and I probably told the two of you this, Mom and Dad this, I'm a complete stranger to your little girl, and she's no longer necessarily a little girl, she's grown up, she's a teenager, but I'm a stranger, and one thing that presents a challenge for me is she's a name on a piece of paper. And not to make that cold or abstract, but the reality is I never meet these children generally. There have been a few occasions in which I've actually conducted a child interview. It's very rare, and that's intentional because I hesitate to draw a child into this process, bring them to a courtroom, sitting down with the judge. It can be very daunting, and my fear and concern is that that's a memory that they'll never be able to remove from their memory bank. And so I'm very sensitive to that. Having been a product of that myself as a young child, I'm keenly aware of that and sensitive to that aspect. But I will tell you, those few occasions when I actually have met with the child, there was something about that interaction. That child came to life for me in a way that I had not seen that child previously. Up to that point in time, that child was a name on a piece of paper, and Mom and Dad were battling things out in court. It became a lot more real to me when I sat down with that child in the courtroom. Sometimes I had attorneys present, other times they decided they didn't want to be present. And there was a personal aspect at that point in time to that case because I knew the child, I met with the child. And again, that's not my intent here. I want to be clear about that because I don't want to involve Abby unnecessarily in these proceedings unless there's some benefit that's going to be ascertained by that. And I say that again because this is your little girl. This is your daughter. And I will never know her like the two of you. And what I want to see happen is I want to work on growing relationships, fostering those relationships. Because the reality is, we're talking about not just the next three years or thereabouts. It's my understanding she just had her 15th birthday.
35 months.
So we're talking about post-emancipation. What are the relationships going to look like then? And what impact will what we're doing now have on those relationships? Because once she's an adult, and we either build bridges now or dig chasms in that relationship that will last beyond emancipation. And sometimes sometimes there's something to be said to look at and analyze, okay, where is this relationship? And sometimes with children, the harder you push, the more resistance they create. And so I just offer that at the outset because that really should be the focus of everything we do when we talk the talk of best interest of a child. That really is the essence of what we should be looking at in trying to grow Abby's relationship with both parents. So that's kind of just my soapbox moment for both of you. I don't know if there have been discussions between the attorneys, and I'm not saying we have to go down that path. I have this time set aside because I do intend to, we need to finish this today and allow these parties some level of closure, again, emphasizing this is not the end. There's a lot of work that's got to be done. The money issues, I'm just not as concerned with, and I'll make my rulings in that regard, but those are, I'm not going to lose any sleep over the money issues. It's the child-related issues that cause me the most heartache and concern. So that being said, and where we were at, and Ms. Beeson, we kind of digressed, but my point to you is that there's been enough established that there were violations of the court's orders because the custodial time did not take place. And we kind of went off on a tangent. You'd mentioned recordings, and I was just asking for the last exhibit I had referenced in my notes was Exhibit 45, which I believe was a reply to opposition. So I'm not sure what number the exhibit is, but how do you desire to proceed at this point?
Judge, the exhibit is number 69.
Okay.
That is a 24-minute video. I have no intention of having the court listen to 24 minutes. If the court believes it would be helpful to listen to a portion of it, to hear the tone and the comments, because again, we're not just talking about violation of custodial time, we're also talking about violation of the behavior order. And you can clearly hear the discussion between mom and dad. You can clearly hear Abby's tone towards mom, that Abby's there during the conversation. So if the court wants to listen to it on the record, I can to the exact time. If the court wants to listen off the record, then you'd have the opportunity to listen to the full 24 minutes. But I can narrow it down between the 5-minute mark and the 12-minute mark.
Let's.
Your Honor, if I could.
And Your Honor, if I could just be heard just really quickly and to follow up on your soapbox, I agree with your soapbox, and I wish you would have had this case when they first separated, because I think even though as a litigator I was very upset with you and I owe you an apology, and my former business partner, Judge Thorne's like, that's going to be fun for you tomorrow. 7 years ago, you ordered one of my clients not to have their new significant other around the child. And I was upset. And I'm like, I'm going to file a writ. We have due process rights. This is not fair. And you were dead right. Because when you introduce it too soon, this is what you get years later. And I just want everybody to be aware, if the idea is to preserve the parent-child relationship for all, Abby wants a relationship with her mom. Abby needs to work on things with dad. But in order to show cause, if mom wants a relationship with her child that's healthy and long-term and being at the wedding, we can do an order to show cause. Your Honor, you're going to make a decision. This is not a sealed case. Abby can see that these pleadings on file. Why counsel never sealed the case, I don't know. But she knows. She can see this case. She's not stupid, guys. You want to do an order to show cause. Think about carefully what you're doing. You're going to further entrench Abby against both parents. And I just hope you guys think about it, because Abby is hurt. And doing an order to show cause, I get it as an attorney, probably would have done it myself if I had never been a guardian ad litem. Now that I've done so many of these cases, I think carefully about it. She's going to know. She's 15. She's very smart. She listens to both of your households. She hears what is going on in both your households. If you think she's in her room ignoring you guys, think again. She hears a lot. She's going to know about this. She's bright. She's smart. And this may further entrench her belief system. So I just want to caution everybody, if this is the route you want to go, think about the long-term effects this could have on both parties' relationship.
Well, listen.
Because she's hearing stuff from everybody. Your guys think she's in her room with the door closed and she's just in Abby world is an unrealistic expectation. You'd be surprised what this little girl has overheard from both households and paternal grandparents' household.
Well, listen, here's where I'm at, and I'm not in a, legally, procedurally, I'm not in a position to stop this from going forward. Again, it is what it is before me. I receive and take evidence and I make rulings. And at the end of the day, that's where I'm at. And I don't know if there's any appetite to have discussion between everyone involved here off the record. I don't need to be part of that. I can step out if there's any value to that. And I'm not saying one way or the other that there is. I've said my piece in terms of where I'm at, in terms of what Abby needs. This is not about the court modifying orders at this point. It is about contempt. There are already stipulations that have been placed on the record. I'm not changing that. I do want to build relationships. If you think there's any value to having any discussion off the record, we can go down that path. But otherwise, I'm in that position where I gather evidence and I make decisions. And that's where I'm at. As much as listen, you know how I feel about this. I've stated that. So I think Mr. Schneider also wanted to make a comment.
I do, Your Honor, and I appreciate the court's comments, and especially Ms. Hauser's comments. Judge, I'd actually filed a motion to continue this trial because I didn't know we were going to have that report. Got that report, so obviously if the motions, I'll withdraw the motion, Your Honor. You haven't ruled on it, but we didn't even talk about it. But I'm withdrawing my motion to continue trial because here we are. But Judge, the tone and tenor of the guardian ad litem report states that Dad was not interfering with the visitation, that these were Abby's choices. And this is my paraphrasing of the report. I think that Ms. Hauser's exactly correct. I think trying to go down and beat up on these parents is going to do more long-term harm and stop that. So, and the violations to be held in contempt have to be willful. And that is addressed in the guardian ad litem report. So I would like to take a 10-minute break and speak with Ms. Beeson off the record and see if we can resolve this here pretty quickly.
That's up to Ms. Beeson. Again, as I said, my role is to gather evidence and make decisions. Ms. Beeson, what's your appetite for going down that path?
Judge, respectfully, we've engaged in several discussions, starting back in 2020, which is why the reunification therapy started. The reunification therapy was stopped by Dad unilaterally. Then it was my suggestion that the parties engage in family therapy. Michelle Hauser is right. Mr. Schneider wanted her to pick the therapist. We didn't ask her if she would agree, but we sent her the communications and she signed off on the stipend order, and she's made it very clear she's not happy about that. So, we haven't even gotten to the point where family therapy has even taken place. My client's tried everything. She's tried to push it. She's tried to back off. She's tried to give Abby space. Nothing has worked. I don't see that a conversation when we already have family therapy in place and we're asking to reinstitute reunification therapy that Dad is not supportive of is going to result in anything. It's not like we've put this family aside and just absolutely litigated this case from day one. We've not. We've made several attempts to help this family. But again, my point is, and we've already talked about the missed time up to October, there's still a mutual behavior order. Dad still violates it. He still makes comments in front of Abby. Moving forward, that can't happen. And if Dad does not suffer any consequences and doesn't realize that what he did was incorrect, that's not okay. And Your Honor does need to have that evidence when you are going through the best interest factors. Absolutely, it is relevant. It's not necessarily about beating up Dad. It's about, does Dad, and that's absolutely willful. He's making these comments about Mom being narcissistic in front of the child. The child is swearing at Mom. Dad does not rein the child in. This is relevant to custody. And how does Mom move forward when this is how Dad is treating her in front of the minor child?
Ms. Beeson is going to testify. I'm going to insist that she be sworn, Your Honor. If you don't want to have a conversation, that's great. But let's get Michelle Hauser she doesn't have the time to sit here for an all-day trial, Your Honor. If I could ask the court to reprioritize, and let's get Michelle Hauser's testimony in, so that we can spend the rest of the day beating each other up.
Well,
And Judge, my comments were nowhere near as testimony as Mr. Schneider's or Ms. Hauser's. You asked a question.
and I appreciate that. Listen, I agree. I'm entertaining discussion from everyone involved, again, because my preference would be to try and make this productive. Let me take a step back, though, in defining custody, because that's been referenced. There is a prior stipulation of the parties that they would maintain joint legal and joint physical custody. The contempt aspect ties into that because that schedule has not been followed, and that's the contempt aspect. But the controlling order before me provides the parties with joint legal and joint physical custody. My aspiration from the bench is that is ultimately the schedule that is going to be followed. The reality is, I recognize it's not being followed now. The contempt aspect deals with whether or not the defendant is going to be able to show cause why he shouldn't be held in contempt. But I don't know that fundamentally changes the stipulated agreement that the parties previously had reached regarding joint legal and joint physical custody. So that being said, from a procedural standpoint, Ms. Beeson, on behalf of the plaintiff, as it relates just to the custody aspect, is that as the controlling order, and I don't, and this case has a long history. This is a 2019 case, and it's 2021. I don't see, and I don't recall anything calling that a temporary arrangement.
It's temporary.
Was that a final resolution?
It
It
was
was
a
temporary.
Temporary, we're all in agreement.
Okay, all right. So let's do this. Again, we got sidetracked on it. So Exhibit 69 has been admitted. What I'd like to do is, I do want to, if you want to play just that limited portion of the clip, let's have that made part of the record. And then I'd like to have any involved, well, Ms. Hauser is here as an attorney, so she can provide examination. So I think we just need to get into that and move forward. So Ms. Beeson, you may proceed.
Okay, and then Judge, my understanding is it's easier for the court clerk to play it so that it is on the microphone and recorded easily rather than off.
So, but it's beginning at a certain time reference?
So if you start at the 5-minute mark into the video, and then we can end at the 12-minute mark.
It's 69, is that correct, Judge?
Yes, Exhibit 69.
Let's see if we can hear it. What's why we can't hear it? Can you hear? We can't hear it.
Yeah, we're able to play it, but we it might be easier, Ms. Beeson, if you play it.
Yeah, because
Yeah,
we
we're not
have it
getting, we're
up.
not getting, yeah, we have the volume all the way up, but we can't hear anything.
I'm going to pull it up and see if it works. Hold on.
Okay.
Measuring, it's all about how you handle stuff.
Right. It is how you handle stuff.
We are here for the decisions and choices that you have made.
You're saying you've
And
made no
consequences.
choices or decisions, Noble?
I'm not the one that walked out and left. Right? You walked
This is
out.
all about me leaving you? The truth comes out. No. Good job. Abby, let's be very clear. I left your father. I didn't leave you.
Actually, because I called you at 1 in the morning that I were in bed or in jail because you were at the bar. And how else would you get home if you're at the bar and you come home drunk?
No, I didn't come home.
Exactly! You didn't come home.
This isn't about you leaving me. Not at all.
You just said
That's
it
the
was.
fantasy land that you've created.
Oh, good. Tell me what I've created.
This is about, you're a narcissist. You need to be selfless. What's important is this thing right here, but you're selfish. It's that old adage that you're saying it's all about me, and that's how you've handled this whole thing. It's not about you. It's about Abby. We sat down last May and included her and talked to her, and we said we were going to handle this in a way that was in the best interest of Abby and take what she wanted into account and work with each other and be flexible. That never happened. This could have been over last May or June, but you've had people chattering in your ear. You've started creating these narratives to
Are you
make
almost
yourself
finished?
feel better.
Because you're making up stories now and you need to stop.
No, I'm not making up anything.
You are very much making up anything.
I believe
Oh.
I'm not even going to talk
Good.
because you don't listen. This is the problem.
Mike, you don't listen either.
Abby, why don't you?
Oh, now you're going to excuse her? It's a little late, Mike. A little late.
So here's what I find interesting.
Here's what I find interesting. You work in a courthouse.
I do.
You understand how motions work.
I do.
This is a joint custody issued by the courthouse.
Yes.
Okay, so why are you not obeying that?
How am I not obeying?
Okay, thank you.
I encourage her to go with you. I ask her to go with you. I'm not going to.
The judge was very clear, Michael, how you're not obeying it. The judge explained it to you. If you didn't understand, you should have asked questions.
I don't think you understand what's going on.
Why do you think I don't understand? You guys don't explain anything to me.
It's right in front of you, Jessica.
You keep repeating that. It's right in front of you, Jessica. What is it? I can't see anything through this security door that you have to keep closed because I'm so scary.
You don't see what you're.
I see what our fighting is doing to her, yes.
Did you read my text?
I sure did. Did you read mine?
Yeah. And clearly you didn't pay enough attention to what I fucking said.
Clearly, you don't know how to speak to adults. So why don't you not speak unless you can be polite?
I don't have to be perfect.
Michael, are you aware that she's failing again?
Where her grades are at.
And
And we're working on it. Working on it.
how is she working
I
on
met
it?
with my guidance counselor. I've talked to my teachers. Do the plan. I'm doing that plan.
I'm entitled to know that plan as her parent.
If I get the plan from Abby, I'll send it to you. It's on an academic plan, is what she told me.
And did they say that she'll be kicked out if she fails?
see what the plan says, I'm sure.
If I get an F in this semester, then through the second semester, then I will be put on probation. That is what I know.
Exactly. Good. So you're aware of the consequences then. Well, at least the school has some. Okie dokie, so I'll call my lawyer and ask if I need to come back tomorrow or if this kind of conversation is sufficient enough.
Dave, this out. Went over.
Michael.
You should be focusing on Abby, and you seem to be focused on
Abby is not.
And trying to hammer me. That's what it seems like to me.
Listen to me, please. I do not, this is not about you. Our daughter is not well and healthy and not passing her classes.
Oh, not healthy.
A and B conversation, please see your way out.
Yes.
Our daughter
There you go.
is not talking to adults the way she should, doesn't have respect for people in general. She's not taking care of herself. She's failing her classes, and she's speaking to her mother like an adult. Okay? She's talking to you like an adult. She's not an adult. She's not even acting like an adult because adults pass their classes and speak respectfully to other adults. You're obviously...
Why do you think she's acting this way?
Because there's no problem with what she's doing when she's here with you.
There's no problem.
Correct, there's consequences.
No consequences. How do you know? You're not here.
Because I've asked you on multiple occasions and you're not telling me, so I have to assume.
She's perfectly fine here. She's happy, in a good mood.
That's great. I'm
So,
glad that you and
She doesn't have the anxiety and stress here that she... At your house stresses her out.
How do you know
That's
that?
why she tears up her fingers. Have you seen her fingers?
How do you know
The
that?
stress and anxiety picks at herself because she's over there and stressed out. Stressed out because you leave her home alone all day. You're at work. She's in that house by herself with people coming and knocking on the door and whatnot. And there's nobody there with you.
Thank you for an explanation 31 days later.
So,
Anything else you'd like to impart me with knowledge?
I'd love to talk to you, sit down and talk to you like we did way back when, but I don't think you listen. You don't you do not have an open mind.
Okay, here's the thing. This conversation back in May.
That's the 12-minute mark, Judge.
And Your Honor, just to clarify, there was no frame of reference and I wasn't provided these exhibits. So when was that audio tape made?
October 23rd,
Of what year?
2020.
Thank you. And Your Honor, I also just wanted to clarify, since I am a guardian ad litem, obviously I still have the jurisdiction and ability to file an order to show cause against Mom too, and all the parties based on that tape, because that was horrifically scary from Abby's perspective. So I just wanted to make sure that that's still something
That
on the
is-
table.
That is part of the guardian ad litem's authority and responsibility. So as far as examination, did you intend, Ms. Beeson, to continue your examination of the plaintiff?
I have just a few follow-up questions about that case, and then we can stop with the order to show cause.
Okay. Let me re-swear in the plaintiff, Ms. Lovelady. If you'll please raise your right hand to be sworn.
You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
For the purposes of the record, can you please state and spell your first and last name?
Jessica, Jessica, Lovelady, Lovely.
Thank you.
All right, Ms. Beeson.
Thank you. What was the result of the end of the conversation, Jessica?
I left without Abby.
Okay. And During your conversation with Mike and Abby on the 23rd, she asks if you received her text messages. Did you file those with the court?
Yes, I did.
Okay. And those are admitted as part of Plaintiff's Exhibit. (46), which has already been admitted into evidence, correct?
Yes.
Okay. You want to take a look at Plaintiff's Exhibit page 40, or Plaintiff's Exhibit 46, pages 10, 11, and 12.
Yes.
And are these the text messages from Abby to you?
Yes.
Okay. The document speaks for itself, and just explain the tone of the text messages.
Your Honor, I'm going to object. I don't have Exhibit 46, and if Ms. Beeson could please share screen this so that I could see it, but I don't have a copy of that.
Okay, well, it has already been admitted, so.
Yeah, I just don't know what they're talking about, so I can't cross. I can't see it.
Is it possible for either party to share that exhibit with the guardian ad litem?
Judge, if you want to give me 30 seconds, I can do a quick Dropbox link and share the prior exhibits with Ms. Thompson directly.
If you wouldn't
No
mind, that
objection.
would be great.
And then I apologize. Ms. Hauser, what is your new email address?
Oh, you're on mute, Ms. Hauser.
It's Michelle at fcpfamilylaw.com.
Okay, Ms. Hauser, the Dropbox link should have plaintiff's trial exhibits that were provided prior to December, as well as the last 2 videos of December 3rd.
I can't open it.
Won't let you?
Can you just share screen it?
No, because what I'm doing trial on is a Surface. It is not my computer. You try this way.
Your Honor, if we could skirmishing, or you want to take a 10-minute break, and I can see if my staff can get it open, because it's not opening on my end.
Yeah, let's take a brief recess. Let's see if we
Thank
can
you,
get
Your
this
Honor.
transmitted.